I thank you very much for being here. I want to thank initially Father Edmund Wolsand, who made the initial contact with the university, and the president and the staff for giving me this honor in being here. Okay. The talk, a study of use and lex as a root of legal authority. Okay. I start off in 2015, the United States Supreme Court, with its ruling on Obergefell versus Hodges, redefined the universal concept of marriage by recognizing the right of same-sex partners to contract a matrimonial civil union. The dissenting side, the originalists, those who voted against, they hold that the Constitution should be interpreted in line with the framers' thinking, and argued that since most states had anti-sodomy laws at the time the Bill of Rights was ratified in 1791, it would then be unconstitutional to concede such rights. This was their opposition, their argumentation. The opposing side, the non-originalists, who say that certain facts, as the originalists hold, of the past are unknown to us, and thus cannot provide a determinate answer to contested questions, ruled that even if the governing majority has traditionally viewed a particular practice as immoral, it is not a sufficient reason for upholding a law prohibiting the practice. This position definitely rendered a capricious understanding of law, which St. Thomas Aquinas called an ordinance a reason for the common good. Not to say that the originalists countered any better. On the other side of the juridical spectrum, there has been such an absolutist approach to law within the last 100 years that it would perhaps make the founder of the doctrine of positivism, Auguste Comte, roll over in his grave if he were to see what has happened. A case in point is a recent Vatican document, Fiducia Supplicans, that calls for the blessing of homosexual couples. The argument from churchmen who uphold this is not necessarily a pastoral one or a theological one. Rather, it is an uncontested submission to the Pope's will, for as they say, quote, "It is better to be in error with the Pope than to be correct without the Pope," end of quote. This argumentation not only disregards the ordinance of reason Aquinas spoke of, it contradicts every principle of the natural law, for, according to an illustrious archbishop of my liking, when an authority uses power in opposition to the law for which this power was given it, such an authority has no right to be obeyed and must be disobeyed, end of quote. Naturally speaking, not all coexisting forms of relationships have some sort of relevance under the law. Only those which acquire a structural social value, that is to say, when it has an external character in its reciprocal rapport with society, as with the institution of the family. And this objective structure is something that same-sex unions objectively do not possess within themselves, because they are limited confined to the ethical personal relationship of affection, which does not lend any social affections typical of law. Law has historically been an incremental part of any society, establishing rules of conduct and behavior for its citizenry in order to secure freedom and moral agency. Used in philosophical, scientific, and religious nomenclature, it goes beyond the strict legal framework from where it derives. Its essence has been understood to be influenced, if not conditioned, by its cultural and intellectual environment and its multidisciplinary ubiquitous status. As a science, law establishes or designates specific conditions, at times unconditional, to be observed within particular circumstances. Law conceals diverse premonitions, which on occasion is solicited to translate a multitude of terms from other languages, such as the Greek nomos and themis, the former nomos meaning a norm, in the sense of custom and of law, whether it is written or unwritten. The latter, Themis, which comes from the name of the goddess Themis, the goddess who personifies justice, law, and custom. In Greek city-states, Athens in particular, law was political since it incorporated the idea of democracy, which in turn gave it validity. In Rome, law was a complex science, a body of doctrines formed in time that was based on both religious, cult, and reason. This allowed jurists to distinguish political dilemmas from scientific ones, thus enabling them to develop an authoritative discipline, legal discipline, of jurisprudence whose roots remain with us to the present day. In classical Latin, the institutional language of the Romans, law is fundamentally expressed by two terms, jus and lex. Jurists developing from the Greek culture, and Greek did not have any equivalent term, shaped a legal system, this is jus and lex, Roman law, shaped a legal system from jus and lex that was by and large more systematic and more pragmatic than the societies that preceded them. In Roman society, jurists tended to opt for the usage of jus over lex, which was originally understood to be founded on the lex dodicim tabularum, the law of the 12 tables in the 5th century BC. The prevalence of jus had a religious fervor due to its association with phos, that is to say, the consent of the gods. In this, religion, as exercised by the pontiffs, the priests who were the jurists of the time, played a significant role in the development of norms when legal problems arose, such as death and burial. Within this background, sacred law met civil law. While lex had been in use since the 5th century BC, it only became predominant when Cicero identified it as the rational principle that undergirded all law. The object of this presentation tonight is not just to examine both jus and lex as a root of legal authority, but as Father Edmund Wolsand indicated, to understand its bearing in safeguarding civilization. Very important for this. Both terms have comparative meanings, and in order to comprehend what each means, they must be individually contextualized, which requires a respective etymological study. Equally important is the historical context in which both jus and lex evolved, simultaneously generating Roman law, and of course, what Thomas Jefferson called certain unalienable rights that are endowed by our Creator. Thus, it is vital to examine three historical events that made this possible. The first, believe it or not, would be the disappearance of Roman law in the West. After the deposition of the boy Emperor Romulus Augustulus in 476, I break off here, I think it's very interesting, I'll open up here parentheses, the very fact that the divine providence, I think, choosing Rome as the font of civilization, the very fact that the last emperor in the West also had the first two names of the founder of Rome and of the first Roman emperor. Very interesting here, providentially. I close the parentheses. Okay. After the eventual fall of the empire in the West, jus and lex, that is to say, Roman law, would essentially disappear as a font of legal authority when the barbarians took over the former territories of Rome. Roman law would survive primarily as an object of study, at least as it was so with the 7th century etymologies of St. Isidore of Seville. This encyclopedic work provided a new horizon to the terms jus and lex, as Isidore expounded them through the Catholic faith. The second important event was the formation of the Corpus Juris Civilis, also known as Justinian's Code, which was promulgated by the Emperor Justinian, more specifically the Digest in 533. It was a definitive collection of the works of Roman jurists that provided the Byzantine body politic with a point of reference for governing. And the third important historical moment to be examined is the renaissance of jurisprudence in the West during the latter part of the 11th and early 12th centuries with the discovery of Roman law. This watershed moment would give birth to the juridical culture with the formation of the jus commune, common law, not to be confused with common law in England. And the jus commune was regulated, written norms of the time, the jus proprium, the proper law. This became possible only with the reticulation with Christianity, Roman law and Christianity coming together, and its fusion with feudal law. As it was in Roman times, beginning with Gratian, canon lawyers introduced the gospel teachings to their juridical deliberation as they sought to defend the individual's natural rights. They thus produced a common legal system in Europe that remained in force until the era of national codification, specifically the Napoleonic Code of 1804. And lastly, it will also serve us to briefly analyze the exposition of Jus and Lex by St. Thomas Aquinas. While not a legal scholar, his contribution unfolded a notion that reminded jurists the most fundamental aspect of law, the lex aeterna, the eternal law of God. The angelic doctor did not draw out juridical aspects of law. He provided a moral, if not a spiritual point of reference for those in legal authority. Just one point, I could have easily named this title, A Study of Roman Law, but we'll see when we get to Thomas Aquinas why I kept Jus and Lex. Okay, the first part here, the inception and complexity of Jus, and here we'll go into the etymology and its historic growth in history. The 3rd century Roman jurist Julius Paulus, also known as Paul, said jus is, quote, that which is always fair and good, such as jus naturale, natural law, end of quote. It could also mean jurisdiction, that is to say, preserving the majesty of his authority and respecting the most custom of our ancestors. Perhaps this is why Cicero referred to it as, quote, jus summum, which could be translated into the utmost rigor of the law or the letter of the law. Indeed, Cicero said that the discipline of jus is to be derived not from the edict of the praetor, as most people do now, I'm quoting him, nor from the 12 tables as his peers, but from the innermost philosophy deduced from the nature of man, end quote. He explicitly proposed to give an account of the legal jus, which employed, in a general sense of the term, a more theoretical, comprehensive, and perhaps more morally laden concept that he associates with the noun lex. The great orator also points out to its rationalistic and the realistic character, which is a principle of practical rationality and natura vis, that is to say, the primary element, the principal force of nature. Interestingly, the notion of jus by the time of the late Republic, the dates I have are 146 to 31 BC, or the Principate 27 BC to 284 AD, evoked a different reality from when Roman society traditionally began in 753 BC, and it did not stop there. Subsequently, this has led many misunderstandings and even deformations of the term jus, more so with its linguistic origin and its historical understanding and usage. The Romans separated jus into jus scriptum, written law, that is to say, the law that derived from any written source, and jus non scriptum, unwritten law, that is to say, custom. With this, while this may seem straightforward, its etymology can be somewhat of a conundrum, if not ambiguous, to say the least. Subsequently, such astuteness has rendered it challenging to provide a clear comprehension of the term. Now, as you see here, jus originally meant juice, or broth. Kind of like orange juice, right? Same thing, we get it from there. A liquid that condenses the essence of a fruit or leaves of vegetables. By metaphor, metaphorically, use comes from the original agricultural gastronomic meaning that would have gone on to indicate the principle of aggregation of a community of men, basically bringing things together. Just like a broth, you're putting so many things in there, it's still contained into that same broth. The same rhetorical understanding. Parenthetically, then, the term justitia, justice, would therefore indicate the consistency of use. Its edibility in the case of broth, its ability when referring to social constraints. At the same time, as you can see here, use originally meant a religious formula possessing the force of law as seen through the expressions of juste nuptiae, wedding laws, and justa funera, funeral rites. Traditionally, use is linked to the Eastern Persian of Eastern language. It's circa 1200 years before Christ. Ios dadaiti, which means to purify. Common opinion says that the word derives from another Sanskrit term, you, to connect, bind, which would mean to unite, in the Latin jungo jungere. Hence, we arrive at the Latin jugum or juvan, which tends to stay in a group. Again, we're staying within the original context of that broth. Another understanding of use is in relation to the ancient Indo-Aryan Sanskrit, circa 1500 BC, the term ios, which means the welfare, health, happiness, for the formula with which a sacred commitment would be assumed. Indeed, both ios and use reciprocally complemented each other. The former indicates a temporary expression of energy and existence destined to decay and destruction, while the latter expresses the idea of a set of rules and thus limitations for life and the rewards and punishments for those following or breaking them. Use is also associated with the Indo-European root ios, yaos, yuals, which referred to the glory brought to the gods, hence the important religion played in the composition of laws. Now we get to the heart of the matter with the use FAS, FAS, the role of religion in shaping use. Ulpian, who lived circa 1170 to 228 AD, one of the lead jurists of his time, has said that if one wishes to learn and understand use, one then needs to study human and divine, and that one needs to have knowledge of what is just and unjust. Law in Roman society, as it is similarly today in Islamic countries, was conjoined to the state religion. The practice of rituals did not necessarily equate observance of morality, nay, spirituality. I open up another parenthesis. The Romans were incredibly religious people. In many ways, as you go into Muslim countries, incredibly religious people. But like with the Jews of old, it was a very legalistic approach to the gods, as you will see. It did not equate spirituality, and I close this parenthesis when in Islam, the 99 names of Allah, Allah the merciful, Allah the benevolent, so on and so forth. These are not attributes of God because, like with Judaism, God is transcendent. He cannot be known. The only thing that can be known is divine will. These attributes, which were also attributed to many of these gods and goddesses in Roman times, were attributes given by man and woman in relation as to how the gods responded to their requests. I close the parentheses. Its legitimacy, FAS, was in consequence with this association to the consent of the gods expressed through signs and wonders that only a priest was capable to interpret. Such casuistry was par for the course in antiquity. As example, the Code of Hammurabi, circa 1755 to 1750 BC, which reflected the king's formation of the virtues of truth and correctness that he claimed to receive from the god Shamash. The notion of FAS, which has its roots in Greek religious anthology, consists in that which is permissible by divine law, in order from the gods, or simply divine law, which was in apposition, to use human law. The aforementioned term themis, which would translate into phos, refers to the verb tetmi, to pose, to place. It correlated to a type of order of divine nature, as seen, for example, with the Themists in the epic works of Homer. They were the divine decisions from oracles that man was required to abide if he wanted to enjoy any divine favors. Yet this relationship was contractual. That is to say, if an individual, for example, felt that his request of a god was not granted, especially after he made the required offering, he could claim that the god did not honor his side of the contract, so then he was free to go and seek another god. Phos was used to define the entirety of positive formal norms encompassing everything licit. By reason it specified a type of justice, that of divine origin, of rules of conduct that established a vertical rapport between the gods and man. It formed, at the judgment of the pontiffs, the rules of compliance for the civility that Roman society demanded. The pontiffs were the ones, as has been stated, who separated the just from the unjust, discriminating the lawful from the unlawful. A reason, Cicero perhaps stated, in order for someone to be a good pontiff, he also needs to know civil law. The object was to safeguard the cooperation and the pax deorum, the peace of the gods. The Romans collectively believed that this divine assistance would enable them to master the unknown forces around them that bred awe and anxiety, which in turn would help them to live prosperously. Jurists could not just make any random or abrupt decisions. They had to carefully weigh and consider the situation at hand. Their deliberations formulated use into a jus sacrum, that is to say, a human law that upheld the rapport between men and the gods. It was, as delineated by Cicero, a body of religious laws that governed a family's sacred objects, masks, etc., items Romans used in conjunction with offerings to the gods, establishing the relationship between their domus, house, and the divine. This inadvertently, we can say, shaped divine law, but I would say that's a bit of a stretch. All these significant manifestations of the life and history of the Roman people were represented in a causal relationship with religion, more so since they believed the will of the gods contributed to the founding of the city of Rome. This explains why the guardians of justice, the jurists, were the pontiffs. Subsequently, one could say that Roman legislation was born from their own cult, or according to use, would derive from the supreme god Jupiter, and not vice versa. Use was therefore presented as the logos, the divine reason that orders and gives the cosmos its form, of the republic, which was understood to be reason embodied in a normative order and social rule, or as Cicero said, in, quote, moral temper and an ethical principle, end quote. This enabled the pontiffs to interpret modus, the plural custom of most custom, vis-a-vis the discernment of the will of the gods, and it served as the juridical oral process until the writing of the law of the 12 tables and thereafter. Even though the Romans had made the distinction between sacred law fas and profane law use, the concept of the sacred origin of Roman law remained. This threefold aspect, that of use fas in most, demonstrated how normative and non-normative approaches can be assembled together towards the common good, or at least for a peaceful coexistence among those living together in a community. The institutional aspect of use, very briefly, as Roman society grew, so did the legal challenges. Use by the 2nd century BC was institutionalized in what became known as the jus gentium, the law of the nations or of peoples. The novelty was that the jus gentium was applied not just to citizens but to non-citizens and foreigners. Because Rome just kept growing, it had to deal with all these traders, not traitors, that were coming into the city of Rome, and vice versa, the Romans who go to their parts of the world and dealing with these people. And so this was inadvertently created because of the situation that, an unforeseen situation that presented itself before the Romans. In contrast, jurists like Paul, who had limited use to the interest of many in a state, use civile, use was inclusive and in reasoned compliance with the standard of international conduct. It became international. Use had likewise taken on of what is always naturally equitable and good, which Paul defined as jus naturale, the natural law. It thus became associated as the law that is natural, that is to say, from the Greek concept of nature comprised of orderliness and moderation, which was able to guide man's actions in his search for justice. Or as Lucius Annaeus Seneca, who lived from 4 BC to 65 AD, stipulated, what the gods granted to mortals. The inception and complexity of lex. In the English language, there's perhaps a reason why law is not expressed by another word, as we have in so many other languages. Given its pragmatic nature to be compendious, the English option for lex over use communicates the conciseness of the term, notwithstanding the term's expansiveness. In Rome, even though lex had been ubiquitous from the early and throughout the Republican periods, such as the lex sacrata, this law established and safeguarded the inviolability of the tribunes of the plebeian class, and it was promulgated in 494 BC. The lex publilia, 471 BC, which limited the role of the curate assembly, binding all the people of Rome to decisions made by the plebeian assembly. And of course, the famous Lex Dodicum Tabularum, the 12 tables, circa 451, 450 BC. It was not, however, until Cicero identified lex as a rational principle that undergirded all law that jurists began to prefer it over use. He thus said, therefore, the most learned men decided to proceed from the law, lege, a lege, lex, is the highest reason, inherent in nature, which enjoys what ought to be done and forbids the opposite. When that reason is fully formed and completed in the human mind, it too is law, lex. Lex, according to Cicero, meant to choose, to select, which would later be contrasted with what Gaius would say, lex est quod populus iubit atque constituit. Law is what the people command and establish. Now, the etymology, these are, I beg your pardon, these were the laws that I mentioned, the lex sacrata, okay, the lex publilia, and the lex tabularum, the law of the 12 tables. Okay? My apologies for that. Okay, the etymology of lex. Some scholars, now keep in mind, its etymology has been a subject of a prolonged debate. Some scholars link it to the Old Nordic log, neuter plural of lag, which would be the root of law, signifying to put in order, put in place. Others side with the Old English akin to the Old Norse log, law, akin to the Old English ligan, which would mean to lay down, to set in place. At first glance, as a deverbal noun, lex is thought to derive from the Latin verb lego, legare, to ordain, to appoint, or lego, legere, to gather, take off, tear off, pick, roll up, look through, or read, denoting originally a collection of legal rules and principles. Lex, like use, is also believed to come from the Sanskrit, in this case, pardon the pronunciation, sera, which would mean a wreath of flowers, garland, chaplet worn around the head, any wreath or garland, circle, series of chain, originally a collection of flowers. Both abstract nouns in Latin and Sanskrit have treated as the same identical root formation as legs, derived from select, to collect, to gather. This suggests a comparison, at least from the point of view of the word formation, semantics, and phonology. Both Latin and Sanskrit terms share the same root formations based on Indo-European leg or slag, to collect, gather. Both are nouns of feminine gender and both belong to the abstract collection. They equally refer to the verbal root indicating the activity of collecting, gathering with a distinct end. The Latin-Sanskrit origin also indicates a certain type of two or more parties coming together. That is to say, some sort of mutual consent. In Rome, for example, nothing the people decided was voted upon that had not been sanctioned by the Senate, even though the aforementioned that we spoke here of the second one, the lex publica, that allowed common citizens to make laws without their approval. This would dispel any autocratic positivist understanding of lex, that is, say, rule by decree as an example upon many, which would come from the verb lego, legare, the first Latin term that we saw. The notion of lex as a divine precept. The earliest known laws, leges, the plural of lex, were those of the Comitia Centuriata, the Roman assembly, which according to legend acted at the behest of Romulus and his successors. Quote, and this is from the Digest of Justinian, after the city had been enlarged to some extent, Romulus himself is said to have divided the people into 30 parts, which he called courts because at the time he facilitated the care of the republic by the decisions of those parts, and the courts brought certain laws, leges, to the people. The following kings also took them, end quote. Romulus' successor, Numa Pompilius, who reigned from 715 to 672 BC, enacted laws he claimed were inspired by the nymph Egeria, the deliverer. Upon her counsel, he instituted religious rites that the gods had consented to, and simultaneously appointed priests to each and every one of them. This would befit the role of religion in Roman society, for the term religio both refers to the worship of the gods and thus what binds men to gods, religare. Nevertheless, while its religious character can be seen in ritual guidelines, for example, the Versacrum, the sacred spring, whose accounts have been preserved by Livy, such attributes are rare. Lex instead tends to be secularized in clear opposition to divine law. The concept of lex in the late Republic. This historical era witnessed a great social political turmoil with its legal systems such as the suspension of the courts, widespread political meddling, and the like. Roman law had become somewhat unmanageable, and thus for the sake of stability, it had to be written in order for it to be concise and effective. Amidst this free-for-all environment, Cicero, who had effectively become a legal practitioner and keen observer of the human condition, was indispensable. As someone who was actively involved in legal practice, his legal consciousness provides a fascinating insight into the period in his transition from use to lex. And he said, it's funny because we first saw he was very adamant about use. My suspicion is here kind of when popes come in and come out, one follows this guy, he leaves, and then the wind changes, they follow the other guy. In the same way, we can see in a subtle way here with Cicero, who then said, quote, the most learned men have favored starting from lex. I am inclined to think that this would be right if, as they defined it, lex is the highest reason inherent in nature, lex est ratio summa insita in natura, which orders what ought to be done and forbids the contrary. The same reason, when it is secured and completed in the human mind is lex. And so they judge that law, lex, whose business is to prescribe acting rightly and to prescribe doing wrong, is practical wisdom. He thus expresses his, he affirms the primacy of lex over use by saying, the foundation of use must be derived from lex, for lex is a principle of nature. It is the mind and reason of the practical wise person. It is the criterion of use and its opposite, injury. A clear shift of opinion. The use of lex, however, began to be phased out when Caesar Augustus ruled from 27 BC to 40 AD and began to rule by what we call imperial constitutions, which were primarily carried out by decree, judicial decisions of first instance or an appeal, an edict, a proclamation, mandates, instructions from the emperor on imperial administrative matters, or epistles, letters to a magistrate, very occasionally to a citizen. And there was also the rescript, the response to the emperor. While the emperor, as the princeps, the first citizen, required the approval of the Senate to enact legislation, and in certain cases that of the Roman Assembly, their assent was nothing more than a formality that ratified his wishes. Just another parenthesis, if I may open. If we were to go back in time today to Rome, when Caesar Augustus ruled, and if you asked, I would like to speak with the emperor, no one in Rome would really know whom you were talking about. Okay. The emperor was a title exclusively to the one who had command of the troops. He was known as the princeps, the first citizen, which was kept unto the Emperor Diocletian until 284. The assuming command of the troops, he also assumed the title emperor. But it's important to understand those terms. I close that parenthesis. Okay. The approval, whenever the Senate, or even when it was required of the Roman Assembly to approve whatever the emperor wanted, was just a mere formality. End of story. It was understood especially by when the Senate had approved Caligula as Tiberius's successor. Then and there, the Romans saw that the days of the Republic were over. Obviously, in retrospect, we can see that the Republic began with Caesar Augustus in 27 BC. Okay, the disappearance of Roman law in the West. This is important. Roman law would become stagnant in the formerly held territories of the empire by the 5th century AD. The barbarians who occupied the lands vacated by the Romans formulated their own norms, such as the leges Visigotorum from the 5th to 6th century, and the lex Salica, the Salic laws, early 6th century. Their laws were not legislation in the modern sense, let alone a centralized system of law, but segments of Roman customs that were first collected and then declared as law. They reflected the transition from the tribal structure to a feudal one in the form of the synthesis of deteriorated Roman slave-owning relations. The remnants of Roman law would primarily survive as a subject of cultural study, specifically with the etymologies of St. Isidore of Seville, composed circa between 615 and 630. Isidore effectively put forth what we call a florilegium, which is a compilation of excerpts or sentences from writings with a purpose to save culture. He rendered a didactic exegesis of use and lex primarily from the works of Gaius and Ulpian. His aim was to reveal the inner and true etymos, meaning of the lexicon, for example, the word symbol stemming from the Greek words for soon, with, and bala, dancing. Isidore's style is fundamentally derivational, whether from a thing's intrinsic component, that is to say, its cause to its extrinsic name, or from its originating motive by process of time to its current locution. Isidore treats both use and lex both distinctively and interchangeably, classifying the former use, a general term, whereas lex is a kind of use. Use is called use because it derives from justum, justice. In this context, justum, is related to what we already went over, the Indo-Aryan Sanskrit of term yos, which would be health. All use, he holds, consists from laws, leges, and customs. In essence, Isidore merely presents Roman jurists penumbrae, their works of use, specifically jus civile, which had to conform with the human and divine reasons. Jus gentium, human laws common to all, and jus naturale, which exists everywhere by instinct of nature. Lex, he said, is the ordinance of the people, which the elders have solemnly ratified with the common people. It is so named not just because it is both read and written, but, very important, it was linked to the divine law of God. Specifically, the precepts of the Torah, the Ten Commandments Moses gave to the Israelites, a concept that was already in use for a few centuries in the church. Now we go to Justinian's Corpus Juris Civilis, his code. Justinian, after just a point here, it has to be understood that once Constantine transferred the see of the empire from Rome to Byzantium, named it after himself, and especially thereafter the deposition of Romulus Augustus, there was a complete break pretty much between the West and the East, to the point that even St. Thomas Aquinas didn't know a single word of Greek, interestingly. A reason why he was very much criticized by Erasmus when the humanists discovered these texts, saying, how could this man be a theologian of the church if he can't even understand the original language of Greek in the Bible? So, just a little polemic thing. You know, my friend here is a Thomas, and I like him, and you like how I ended with Thomas Aquinas, for sure. Okay. But it's important to understand that because thereafter Justinian, after his successful reconquests in Italy, North Africa, and Spain, he saw the need to regulate the empire with a centralized legal basis. He thus took it upon himself to have a definitive collection of Roman law. In 529, he promulgated the Codex, Code, the first of 4 volumes of what would become the Corpus Juris Civilis, the body of civil law. This was not a legal code in the sense we understand it to be today. It was rather an outline of actual laws of the Byzantine Empire that cited imperial constitutions, as we saw prior, legislation, and pronouncements. Work actually began a year prior when Justinian appointed a commission of 10 men to produce the code. They began with the 3rd century AD Codex of Gregorianus and the Codex Hermogenianus and the Theodosian Code of 438. Go here. In this, jurists harmonized the leges and jura, which the requirements of Christian ethics and customary law of the Hellenized East. The second part, the digested, the digest, or the pandecta, that is to say, the all-containing. This is, for us, the most important part in the collection. It was a collection and writing and summary of all the writings Justinian had at hand on law and justice of the classical jurists. No one under his jurisdiction was permitted to cite juristic works or imperial constitutions that were not found in the digest. The third part, the Institutiones, institutions, promulgated in 434, it formed the third section. which summarized the digest and was intended as a manual for those who studied law. It's also the briefest part of the 4 volumes. Both the institutions and the digest followed what seems to have been a tradition of textbooks of earlier Roman jurists, which begin with a brief definition of use. This introductory material speaks of jus civile, positive law, but focuses on the interrelation between jus naturale and jus gentium. In the institution, one sees a development of jurisprudence from the digest with respect to jus naturale and jus gentium, which, according to Alpin, are contrary to each other. As he originally said, jus gentium is that which nations use. It is easy to understand that it diverges from jus naturale because the latter is common to all animals, while jus gentium is common only to humans in their interrelations. End of quotation. The jurisprudence that we see within the institutions, we have a quote here: "What natural reason has truly established among all peoples, that is observed equally among all peoples, and is called jus gentium, since it is that law which all nations make use of. Jus gentium is common to every human type nation, for because of the force of exigencies and human necessities, human nations have established certain measures for themselves. Wars have arisen and given rise to captivity and slavery, which is contrary to jus naturale." Very important. Here we see real jurisprudence, real deliberation. The 4th volume of the code was promulgated a good 20 years later in 556. The novelle, also known as the New Laws after the Code or the Novels, it primarily consisted of the new laws created from that time onwards, as well as a compendium of Justinian's own constitution. Unlike the 3 original books, the novelle appeared in Greek, the common language of Byzantium, which, by the way, it's something to be admired. While it was a Greek-speaking society, Justinian made sure he kept the works of the Roman jurists in Latin, which is very interesting. Roman law, the digest, would eventually make its way to the West when it appeared in present-day Tuscany at the Placitum of Marturi in 1076. In 1089, just over a decade later, the Universitas Studiorum, the University of Studies in Bologna, Italy, was founded. There, Gratian, the father of canon law, in his Concordia Discordantium Canonum, commonly referred to as the Decretum, and canonists thereafter began to comment and reflect on the digest, through which they could review and regularize laws and develop generally recognized standards for legal procedure. This became the watershed moment for the renaissance of Western jurisprudence as canonists integrated Roman law with the then canon law, which provided a body politic, non-statutory rules it had to employ in order to resolve dilemmas of the time vis-a-vis feudal law, merchant law, and the like, or as it was with the jus propria, the proper laws, to regulate them. Jus and lex would serve as a criterion for defense of the individual's rights and a measure for human behavior as demanded by God. This era would have a profound and lasting impact on legal systems, as it would see the development of the jus commune. Now, canon law obviously differed from civil law, but yet by this time they became so intertwined that one could not understand either without the other. The civil law was concerned with justice in order to guarantee happiness and prosperity on earth. Canon law, on the other hand, was focused on justice to ensure the salus animarum, the salvation of souls. And so medieval jurists, again beginning with Gratian, did not employ these terms of jus and lex in a legislative or statutory manner. Rather, by consolidating Justinian's code with the Corpus Juris Canonici, the body of canon law, they restored vigor to a society that had for centuries found itself in a social juridical vacuum. While Gratian's decretum was never approved by the Catholic Church, just like the commentaries and teachings of canon lawyers at the time, it nevertheless became authoritative for both ecclesiastical and civil authorities. Use, which had evolved into our present-day understanding of right, became a constant reminder. This was a result of the deliberation of the canonists, became a constant reminder to canon lawyers and churchmen alike of the transcendental significance of a legal system. It existed only to distinguish right from wrong, but as a source of justice, equity, and natural rights. In other words, it stipulated and implemented that which nature itself demanded, the virtues that ought to be part of society. Use was one with nature, for which there is a natural law, jus naturalis, that is to say, a kind of natural propulsion implanted by nature in each human being to do good and to avoid evil. This law of nature was now understood to be a reflection of the divine wisdom and will of the triune God, Father, Son, and Holy Ghost, which holds the same authoritative weight as human law as with Scripture. Thus, nothing is commanded, this is a quotation from the Decretum of Gratian, thus nothing is commanded by natural law except that which God wishes to be done, and nothing is forbidden except that which God forbids to be done. Hence, whatever is regarded as yielding to divine will or to canonical scripture or to divine laws, leges, natural law, he's still using use, is also to be given precedence over it. Therefore, ordinances, whether ecclesiastical or civil, if they are shown to be contrary to natural right, are to be altogether excluded, end quote. Lex would be broadened from Isidore's notion of the law taught by Moses to the doctrine revealed by Jesus Christ, more so by connecting the natural law to the golden rule to treat others as one wants to be treated. It too would be comprised in the jus naturae, the laws of nature, though not everything contained in the law and the Gospels pertain to it. Certain things in the lex are more moral precepts, like the commandment, thou shalt not kill, while others are symbolic tenets, such as those concerning sacrifices. The consolidation of the corpus juris civilis and the corpus juris canonici, the body of civil law and the body of canon law, historically served as the basis for a highly sophisticated and technical education law in the medieval universities of Italy and southern France, and then it expanded into other parts of Europe. As the graduates from these universities spread throughout Europe, their methods of logical elaboration became authoritative and inadvertently paved the path for the institutionalizing of the jus commune. The jus commune derived its authority not from political power, but from its scientific character, that is to say, from the common opinion of scholars, which was based on the rapport between jus and lex. It was not legislative, but juridical, dictated by reason. In many ways, a copy of the jus gentium in the times of Rome. Now we get to our friend St. Thomas Aquinas. Okay. The nomenclature of jus and lex would reach its apex in the 13th century Europe under St. Thomas Aquinas, even though Western Christendom was already united under the jus commune. There were nevertheless legal and ethical issues that had to be addressed in both the public and private sectors. Jus and lex would be aligned to man's disposition of virtue, his moral, intellectual, natural, and supernatural modes, and earthly perfection in Christ-like action and contemplation. Jus for Aquinas meant the right thing to be done according to the rule of mutual reciprocity or equality of conduct, commenting on Cicero's notion that jus is natural by its very principle, since it is instilled in nature vis-a-vis human law. He parallels jus to the juridical understanding of the time, which included positive law, but he terms it jus positivum. This was a new term for describing man-made law that canon lawyers gradually introduced into ecclesiastical jurisprudence at the end of the 12th century. It had been argued by scholars that since, quote, canonists used the words used to mean a subjective right, and when Aquinas, I'm quoting a professor of mine who was quoted by someone else in a book, canonists often used the word used to mean a subjective right when Aquinas discussed the same or similar issues. He reflectively borrowed their language, end quote. For example, in his commentary on the sentences of Peter Lombard, where he cites Justinian's code to explain how the status of serfdom cannot be an impediment to marriage, he says, further, if marriage is impeded, the impediment would come from natural law jus naturale or from positive law jus positivum. However, natural law does not dictate an impediment, since according to natural law, all men are equal. In the beginning of the digest, this is still Aquinas, it is said that servitude had no place in natural law, and positive law descends from natural law, as Cicero says. And therefore, according to law, no law, nullum jus, can servitude be an impediment to marriage, or in the law. Okay. End of quote. The angelic doctor's usage of use is thus understood in accordance with Gratian's explanation of the natural law as a right because it is the object of justice. For this to be accomplished, one was to exercise proper judgment, which must be in accordance with the written laws, leges. Hence, use in the proper sense of the term is that which is correct or moral. It is a component of justice, which always implies a subject, that is to say, a person in relation to one or more subjects. I'll go now to the lex. And this is my favorite part, by the way, of the Summa, even though I'm not a Thomist. Father Inman and I have heated discussions over beer or whatever at times with this. Okay. St. Thomas clearly states that lex is altogether different from use because, just as Isidore stated, the former is a written decree, whereas the latter is an expression of a right. The term ratio seems to express lex as a measure of use, that is to say, the principle in which use is determined by justice. Lex instead has a statutory character because God is the supreme legislator. This is very key. It is a rule of measure of acts whereby man is induced to act or is restrained from acting. For lex is derived from ligare, to bind, because it binds one to act. This is why he defines lex as an ordinance, a reason for the common good made by him who has care of the community and promulgated. Its goal is to administer or conduct human behavior which poses norms for this end. For this reason, he classified lex into three distinctions in his Summa. The one, the eternal law, the supreme divine reason which governs the world and is unchangeable and includes his foreknowledge and preordination of created beings and their contingent motions and actions. It is not ordained to any extrinsic end, but the end of divine government, God himself. Eternal law is the basis of all other forms of law, for the world is moved and governed by God. The second distinction, the natural law, lex naturale, the law that is inscribed in man for him to partake in the rule, in the measure of things. That is to say, the rational creature's participation of the eternal law. A distinction from jus naturale, that which is inherent within man's human nature. This is specifically lex naturale. This is the law of God that's literally written in the heart of man. Then the third distinction, human law, which can be translated into customary positive law, a system of law promulgated and implemented within a particular political community by political superiors as distinct from moral law, existing in an ideal community or in some non-political community. In essence, it is also customary law, in which the making of law pertains either to the custodian of the community or to the people as a whole, and such laws, being that they are in ordinance or reason, emerge the development of custom. Aquinas does not use the term positive law with lex again, but human law, which is a dictate of the practical and speculative reason, drawn from various sciences and knowledge unknown to man, which determines certain matters. Now, there is a fourth classification of law, which I do not include into the three because he does not, ironically, dedicate a full question to it, and that is the divine law, divine revelation. These are God's precepts revealed in both the Old and the New Testaments, which are necessary for human conduct primarily because it is by law that man is directed how to perform his proper acts in view of his last end, which is eternal happiness. For this reason, divine law, lex divina, which, quote, presupposes the natural law, had been given to man because it had begun to be obscured on account of original sin. This is something that the Catechism of the Catholic Church picks up and even cites Saint Irenaeus, who said that because of the effects of original sin, we as human beings would have a problem living according to the natural law, and so then God had to provide his divine law to us. Okay. And our conclusion. In 625, the Dutch scholar and jurist Hugo de Groot, better known as Hugo Grotius, also known as the father of modern law, altered the universal understanding of jus naturale when he said that the law of nature will still exist, etiam si daremus deum non esse, even if we were to say that there is no God. While Grotius had the best of intentions, specifically to invite the then body politic to propagate just laws that would ensure peace in society, he inadvertently reduced the natural law to a subjective, if not relative, philosophical concept, which eventually paved the way for the atheistic doctrine of the Enlightenment. In the 20th century, the Austrian jurist Hans Kelsen held, quote, that norms cannot emerge from social realities. Instead, norms can only emerge from themselves, end quote. In fact, law, as he saw it, was both an order of human behavior and a coercive order. This was not a denial to the interaction between jurisprudential theory and philology. In his pure theory of law, Kelsen was exclusively concerned with the part of knowledge that deals with law, including everything that does not technically belong to it, such as the fluctuation of man that alters law itself. This perhaps may have some validity in the sense that the principle of lex for Cicero always existed in the nature of things, more so for Aquinas, in that all legal norms of a given legal system ultimately derive their validity from one basic norm, for him the eternal law. The ought, however, must always presuppose a certain point of view, which is constituted by the basic norm, this is for Kelsen, which is constituted by the basic norm of the relevant normative system, regardless if it is religious, ethical, or legal. The dilemma in this is the failure to ground the choice of the relevant point of view in anything like reason or reasons of any kind, which is just the opposite of the rationale of jus and lex. Thus, law becomes an end to itself, as it was with the racial Nuremberg laws under Nazi Germany. In this case, law risks in becoming an instrument of a tyrant to impose his will on others, just as it was under King Henry VIII in England, when the king, not getting the permission to divorce Catherine of Aragon from Pope Clement VII, he separated from his church, manipulated Parliament to legislate that a layman would now have full reins over the church and all spiritual matters. If one disavows the fact that all laws stem from God's eternal law, as our friend Thomas Aquinas stated, then one reduces jus naturale to a subjective interpretation of nature, as Grotius did, which then would lead to a fundamental positive notion of lex. Consequently, all rational jurisprudence ceases to exist. The law becomes absolute. The will of the legislator cannot be contested. It is today in communist China and in Islamic countries, or as it is in Western nations that impose emotional hedonistic notions, such as those dictated by the LGBTQ+ movement, as human rights. Justice then is no longer the object of law, since it is no longer rooted in the creative reason of God. If laws are not based and developed on this type of jurisprudence, then, as already indicated, individual persons become subject to the whim of the body politic, or vice versa. If, however, government officials and jurists revert to the proper concept of the jus in lex, then the common good of society can be arrived at. And I end here. I thank you for your devoted attention, and I'll take if any questions need be.